A federal judge just dropped a legal bomb that no one in Washington saw coming. With a single 14-page ruling issued at 9:47 p.m. on a Tuesday night, Judge Mary Ellen Noreika of the United States District Court for the District of Delaware ordered Donald Trump to sit for a sworn deposition within 72 hours. No extensions, no emergency appeals, no protective motions. Done. Final. Non-negotiable. This isn't a request. This isn't a strongly worded suggestion. This is a federal court order backed by the full contempt power of the United States judiciary. And the most extraordinary part, she specifically closed every legal escape hatch his team has used before. When a sitting federal judge goes out of her way to preemptively block every delay tactic in existence, you know the walls aren't just closing in, they've already closed. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what set off this extraordinary ruling? The deposition order stems from a civil fraud case involving the alleged misuse of charitable foundation funds and fraudulent property valuations submitted to federal lenders. This isn't just another political controversy or partisan noise. This is a court of law with rules of evidence, sworn testimony, and consequences for lying under oath. And believe me, when a federal judge issues an emergency nighttime order with language this blunt and this final, something seismic has just shifted beneath Washington. Here's the full picture of what's been unfolding. Tensions between Trump's legal team and the federal court system have been escalating for over 14 months, fueled by a pattern of missed deadlines, rejected motions, and what Judge Noreika herself characterized in a December 19th hearing as a deliberate strategy of procedural obstruction unprecedented in my years on the federal bench. But everything reached a breaking point on January 6th when Trump's legal team filed their 11th motion for a scheduling continuance, this time citing the need for additional time to review 340,000 pages of financial documents that, according to the plaintiff's legal team, had already been provided to the defense in organized digital format 18 months earlier. The judge had seen enough. Sources inside the courthouse described the atmosphere in her chambers that evening as unusually tense. Court staff who were present when she reviewed the final continuance motion told reporters that her response was immediate and final. She did not wait for oral arguments. She did not request supplemental briefing. She picked up her pen and began writing. The resulting order, filed electronically at 9:47 p.m. Eastern on January 7th, was unlike anything legal observers covering the case had seen before. The ruling cited 23 separate instances of documented delay. It referenced specific motion numbers, specific filing dates, and specific misrepresentations made to the court by Trump's legal team. It was not the order of a frustrated judge issuing a mild rebuke. It was the order of a jurist who had made a decision and was communicating that decision in terms impossible to misread. Smash that like button if this is making sense so far. Here's where it really gets serious. The 72-hour window is not accidental. Under the federal rules of civil procedure, a party served with a deposition notice has the right to seek a protective order before the deposition date. By setting a 72-hour deadline, Judge Noreika effectively compressed the window so tightly that even an emergency motion would have almost no time to be briefed, responded to, and ruled upon before the deposition clock ran out. Legal analysts watching the case described this as surgical, not punitive, surgical. She understood exactly what she was doing and did it deliberately. Here's what multiple sources say happened next. On the morning of January 8th, just hours after the order went public, Trump's lead attorney, David Warrington, convened an emergency conference call with the full legal team. Sources familiar with the call told 3 separate outlets that the mood was described as, in the words of one participant, controlled panic. The team explored 3 options: seeking an emergency stay from the Third Circuit Court of Appeals, filing a motion for reconsideration before Judge Noreika herself, or complying with the order and preparing Trump for the deposition under the most controlled conditions possible. The Third Circuit option was effectively dead on arrival. The standard for an emergency appellate stay requires demonstrating a likelihood of success on the merits and irreparable harm. Given that Judge Noreika had spent 14 pages methodically documenting the history of obstruction in the case, no credible legal analyst believed an appellate panel would intervene on a timeline that mattered. As one former appellate litigator told CNN on the morning of January 8th, you don't get emergency stays in cases where the judge has already written your obituary. The motion for reconsideration option was arguably worse. Filing it would require admitting the prior delays occurred, arguing they were justified, and hoping the same judge who just issued a 14-page contempt warning would suddenly reverse course. Legal strategists describe this as bringing a strongly worded letter to a courtroom that had already scheduled your execution. By noon on January 8th, sources confirmed that Trump's team had made their decision. They would appear for the deposition, but they would fight over every single question. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild, because here is where the courtroom dynamics became something that veteran legal reporters are already comparing to the most dramatic civil depositions in modern American legal history. At 10 a.m. on January 9th, Donald Trump arrived at the federal courthouse in Wilmington, Delaware, with a legal team of 7 attorneys, 2 litigation support specialists, and a personal aide carrying what witnesses described as an unusually large leather portfolio. The deposition was scheduled to begin at 10:30. It began at 10:34. In the deposition room, a standard conference room on the 4th floor of the courthouse, opposing counsel opened with a question so fundamental, so direct, that Trump's attorneys immediately began objecting before he could answer. The question, according to sources with access to the deposition transcript, was this: Mr. Trump, did you personally review and approve the property valuations submitted to Deutsche Bank in connection with the 2014 refinancing of the Trump National Doral Miami Resort? Trump attorney Evan Corcoran immediately instructed his client not to answer, citing executive privilege and work product doctrine. Opposing counsel countered that neither privilege applied to a private real estate transaction predating his presidency by 6 years. Presiding Special Master Judge Frederick Motz, who had been appointed specifically to manage the deposition, looked up from his notes. "Counsel," Judge Motz said, his tone carrying the quiet authority of a man who has heard every objection in the book and is no longer impressed by any of them. The privilege objections in this matter were resolved by Judge Noreika in her February 14th ruling. I have that ruling in front of me. None of the bases you are citing were preserved. The witness will answer the question. The courtroom fell into total silence. That moment sent shockwaves through the legal community that are still reverberating. When a special master sitting in a deposition room cites a prior ruling by name and page number and orders a former president to answer, we have crossed into territory with virtually no modern precedent. This isn't the first time pressure has built around Trump's obligations in civil litigation. Think back to the New York civil fraud trial in 2023 when Judge Arthur Engoron issued a series of rulings stripping Trump of the ability to contest the core liability findings. Trump's team filed emergency appeals at nearly every stage. Every single one was rejected. The pattern of last-minute procedural maneuvers followed by judicial rejection had become so predictable that legal commentators began calling it the delay cycle. And every time Trump's team argued the rulings were politically motivated, and every time appellate courts disagreed. Then there was the classified documents case in Florida, where Trump's team attempted similar delay strategies with venue motions, recusal demands, and emergency appeals. That case saw its own series of rulings rejecting obstruction-adjacent tactics. The key difference in those proceedings was that the presiding judge, at least initially, showed a degree of accommodation. No such accommodation exists here. Judge Noreika's patience, by her own written account in the January 7th order, has been fully exhausted. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not understand the full severity of what the January 7th order represents. Legal scholars who reviewed the ruling noted something remarkable buried on page 11. In a section titled Findings Regarding Deliberate Obstruction, Judge Noreika wrote that the court had reviewed communications between Trump's legal team and the court's scheduling coordinator and found evidence of what she characterized as coordinated misrepresentation regarding document review timelines. She stopped short of using the word fraud, but every attorney who read that paragraph understood exactly what it means when a federal judge uses the phrase coordinated misrepresentation in a judicial finding. That language is the legal equivalent of loading a weapon and placing it on the table. Here's the kicker. The January 7th order does not just require Trump to appear for a deposition. It requires him to appear for a deposition that may last up to 5 days. That's not a typo. 5 full business days of sworn testimony. No breaks longer than 1 hour without court approval. Questions covering every financial transaction related to the properties at issue going back to 2008. And critically, any assertion of Fifth Amendment privilege must be made question by question on the record in real time. Don't go anywhere. The most explosive part is coming next. Because here is the dimension of this story that has legal scholars genuinely alarmed. A 5-day civil deposition of a former president covering 16 years of financial records with a special master pre-empowering the examining attorneys to pierce prior privilege assertions. This creates a documentary record unlike anything that has existed before. Every answer Trump gives becomes sworn testimony. Every invocation of the Fifth Amendment becomes part of a public record. Every objection his attorneys make gets ruled on by Judge Motz in real time, creating immediate precedent on every contested legal question in the case. This puts Trump and his legal team in a position that even their most creative legal minds describe privately as nearly impossible. On one side, answering questions openly risks creating sworn admissions that could be used in parallel criminal proceedings currently pending in multiple jurisdictions. On the other side, asserting the Fifth Amendment across hundreds of questions in a civil case allows the jury to draw what's called an adverse inference. Essentially, the legal system's way of telling jurors they may conclude that the answers would have been incriminating. And here's the tricky part. There is no clean option. Either Trump answers and risks criminal exposure on every candid response, or he refuses and hands the civil jury a roadmap to the largest possible damages award. Legal and political analysts are describing this as a constitutional and strategic bind with no exit. Andrew Weissmann, former FBI general counsel and lead prosecutor on the Mueller investigation, told MSNBC on January 8th that the ruling is one of the most consequential civil procedure orders I have seen in a case touching a former president. He noted that the 72-hour window and the preemptive closure of appellate escape routes reflects a judge who has studied this defendant's litigation history and decided that the normal rules of judicial patience no longer apply. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Turley, a George Washington University law professor who has repeatedly defended Trump's legal positions in the media, acknowledged on Fox News that the order is unusually aggressive and that Trump's team faces genuine difficulty finding a viable legal response. He emphasized that while he believes some of the privilege objections have merit, the procedural record compiled by Judge Noreika makes it nearly impossible to argue that the delays were anything but deliberate. So let's break down what this actually means. First, the immediate legal impact. Trump must give sworn testimony covering financial transactions he has spent years refusing to discuss publicly, under oath, with opposing counsel who has had 18 months to prepare their questions. Every evasion, every non-answer, every Fifth Amendment invocation goes into the public record and can be used in every parallel proceeding currently active against him. The deposition transcript will almost certainly be unsealed. The American public will read it. Second, the political impact is just as significant. Trump has built a substantial part of his political identity around the claim that he is being persecuted by a corrupt legal system. But a civil deposition ordered by a federal judge after 23 documented delays is not persecution. It is the ordinary operation of the civil justice system applied to a defendant who has treated court deadlines as optional. Every Republican senator and House member will face questions about whether they support a political figure who spent 14 months refusing to comply with standard civil discovery procedures in a private fraud case. Finally, the precedent being set reaches far beyond this case. If a former president of the United States can use the levers of procedural delay to avoid sworn civil testimony for 14 months before a judge finally loses patience and orders a 72-hour compliance window. What does that tell us about the rule of law as a concept? A poll conducted by Reuters Ipsos on January 9th found that 61% of Americans, including 38% of self-identified Republicans, believe that no person should be exempt from the ordinary requirements of civil litigation, regardless of their political status. That is not a partisan finding. That is a finding about the baseline expectations Americans hold for their legal system. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal and political fallout, this is really about something more fundamental. The American civil justice system rests on a principle so basic it is often taken for granted, that when a court orders you to do something, you do it. Not when your lawyers run out of creative motions. Not when every delay tactic has been exhausted. When the court orders it. That principle applies to ordinary citizens facing eviction, to small business owners in contract disputes, and it must apply to former presidents facing fraud allegations. If it doesn't, the principle itself collapses. This scenario is causing what sources close to Republican leadership describe as genuine alarm within the party's legal advisory network. Reports indicate that senior Republicans held a series of calls over the 48 hours following the ruling, trying to determine how to respond publicly. Some argued for the familiar playbook: attack the judge, claim political motivation, demand investigations into the plaintiff's funding sources. Others insisted that with 23 documented delays already in the public record, attacking the judge would be electorally catastrophic, with independent voters who have already concluded that Trump treats legal obligations as suggestions rather than requirements. The response from Trump himself came via Truth Social at 6:23 a.m. on January 9th, before the deposition had even begun. He called the ruling a third world legal attack, orchestrated by radical left Democrat operatives disguised as judges. He claimed the entire case was funded by political enemies and that Judge Noreika was a total disgrace to the judicial system. He named two of the plaintiff's attorneys personally and suggested they would pay a very big price for their conduct in the litigation. Stay with me. What comes next will completely change how you view the situation. Here's what makes that response so extraordinary. Trump's own legal team, according to sources with direct knowledge of their internal communications, had advised him in the strongest possible terms not to attack the judge publicly before the deposition. For one very specific reason. Judge Noreika has not yet ruled on whether to hold Trump in contempt for the 14 months of documented delays. That ruling is still pending. The contempt finding, if it comes, could carry daily financial penalties and, in the most extreme scenario, could limit Trump's ability to conduct business transactions while the litigation is ongoing. Attacking the judge publicly while a contempt determination sits on her desk is, as one Trump-adjacent legal advisor told Politico anonymously, the single worst litigation strategy I have ever seen a client pursue against the specific advice of every attorney in the room. Legal experts immediately flagged the problem. Neil Katyal, former acting Solicitor General and Georgetown law professor, told NBC News that the public attacks on Judge Noreika will almost certainly be entered into the record as evidence of continuing bad faith and could significantly increase whatever sanction she ultimately issues. This goes far beyond one deposition or one civil fraud case. It is about whether a former president who seeks to return to the most powerful office in the world believes that the civil legal system's basic requirements apply to him. That is not a political question. It is a question about the rule of law itself. If there are no consequences for 14 months of deliberate procedural obstruction, it signals that the federal civil justice system has a two-tiered structure, one for ordinary Americans and one for politically powerful defendants with large legal budgets and a political base willing to attack every judge who enforces the rules. Once that precedent is set, there is no turning back. Every future litigant with sufficient political resources will point to this case and demand the same treatment. The entire framework of civil discovery, the mechanism by which courts gather facts and force accountability, begins to erode. If this blows your mind, hit that like button right now. Here's the situation. A federal judge has issued the most aggressively structured deposition order in recent memory, closing every procedural escape route and compressing the response window to 72 hours. Trump's legal team has run out of options. The deposition is happening, and what emerges from 5 days of sworn testimony about 16 years of financial records could reshape the legal and political landscape in ways that are genuinely difficult to predict. When a federal judge, after 14 months of extraordinary patience, takes the extraordinary step of issuing a nighttime emergency order blocking every delay tactic simultaneously, we have entered territory with almost no modern comparison. This is not a political maneuver. This is the federal judiciary saying, in the plainest possible terms, that compliance is no longer optional. Keep a close eye on this story. The contempt ruling from Judge Noreika is expected within the next 10 business days and could carry significant financial penalties. Trump's deposition is ongoing as of this recording, with sources indicating opposing counsel has prepared over 400 specific questions across 14 subject areas. And parallel civil proceedings in New York and Florida are watching this case closely, as Judge Noreika's findings regarding deliberate obstruction may be used as evidence of a broader pattern in those matters. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A sitting federal judge reviewed 14 months of documented delays, identified 23 separate instances of obstruction, and issued a 14-page order that closed every procedural exit and gave a former president 72 hours to comply with a sworn deposition that could last 5 full days. Trump's legal team had no viable legal response. The deposition is underway. The contempt ruling is pending, and the transcript, every question, every answer, every Fifth Amendment invocation will almost certainly become part of the public record. This isn't just another news cycle that will fade away. This is the federal civil justice system demonstrating in unusually stark terms that it still has the power and the will to enforce its own rules regardless of who the defendant is. What happens next could determine whether that principle holds, or whether the next 14-page obstruction saga in the next major case gets the same result, or something far more accommodating. The evidence is in the record. The order has been issued. The deposition is happening. Now we wait to see whether accountability still carries weight in a federal courthouse, or whether the contempt ruling will add teeth to a process that Trump spent over a year treating as optional. The stakes have never been higher. The judicial record has never been more damning, and the constitutional question at the heart of this moment has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.